And even court has no control over his list. The lists are beyond human potential. Next judgment is Pepsi Food. There, section 254.
Yes.
There was an amendment in the Income Tax Act, section 254, within bracket 2 capital A was inserted. That a stay granted by the tribunal would get automatically vacated after 1 year. And High Court, this Honorable Court, said this, and this, I would respectfully place for your Lordship's consideration. Such provision treats unequals equally.
Yes.
The person who has an interim order inuring in his favor, has once persuaded the competent court to grant it. The respondent has done nothing to get that vacated. So unequals are being treated as equals, and therefore also, this needs to, this is not a correct law. Then, next point is, whenever any court, passes an order, it passes broadly, strong prima facie case, balance of convenience and irreparable injury. After 6 months, whether those conditions, these three conditions, change or not, the judgment says it stays vacant.
Yeah.
Whenever a time frame is to be stipulated, it is always for the competent legislature to do.
Even those have been held to be, by and large, directory.
For example,
in the IBC, Insolvency and Bankruptcy,
IBC, or Arbitration Act,
the Consumer Protection Act.
Consumer, that after particular days, your right to file appeal goes. Because of the overall scheme of the act, the intent of the legislation, etc., etc. Because there is one focused area which the court is examining. This is not too wide an area, my lord. It can be a civil suit, it can be a criminal trial, it can be criminal revision, it can be 482, it can be civil revision under 115, it can be superintendent's jurisdiction under Article 227. But nothing is considered, and, my lord, a judicial mandamus is issued.
Generally speaking, directions for the completion of a trial proceeding by the legislature within a certain stipulated period is held to be directory. But since an appeal is a creature of a statute, directions for the legislative prescriptions for filing of appeals on limitation have been held to be mandatory.
Mandatory.
Like in section 34(3) of the Arbitration Act. Or section 61 of the Insolvency and Bankruptcy Code.
The curtain falls. You
can condone a delay up to 15 days, beyond 30 days, but no further.
Because time is the essence of that particular legislation. So time fixation, first of all, has to be by the competent legislature, and for the purpose of the object which that particular act seeks to achieve. It is always object specific. Then, my lord, your lordships are aware, my lord, Order 8, Rule 1 required that unless you file your written statement,
yes,
the court can extend only for 30 days. So that came to be challenged. I will read only 4 lines when, my lord, this honorable court dealt with, my lord, the challenge. That your lordships would find at page 4. The citation is Kailash versus Nanku, 2005, 4 SCC 480. There are 27, only last 3 lines. That is relevant, my lord, for the entire discussion, but I don't wish to, my lord, take time on that, my lord. But last 3 lines are crucial. The object is to expedite the hearing and not to scuttle the same. The process of justice may be speeded up and hurried, but the fairness, which is a basic element of justice, cannot be permitted to be buried.
Kailash judgment, Mr. Dwivedi was the amicus, no? I was agreeing.
My lord, any judicial discretion, my lord, should be left, my lord, to the concerned court, my lord, namely the High Court, and in some cases, my lord, District Court. But generally, the question of stay of trial does not arise in case of, my lord, proceedings before the District Court, except in case of a criminal revision or some civil revision. Generally, it is High Court.
Yes.
So, my lord, while the problem, my lord, is there, trials are stayed and it has its own ramifications, but this is not the solution. These are my respectful.
Thank you, Mr. Solicitor. Yes, Mr. Ansaria.
I appear in the IA number, my lord, 258440 of 2023 on behalf of Guwahati High Court Bar Association. And we are supporting, Lord, both Mr. Dwivedi and the learned solicitor, my lord. Just to add one or two aspects. But wherever limitation is provided, it is upon the litigant, my lord. Courts have put a fetter on the litigant. Section 34 Arbitration Act, appeal, and not upon the courts, my lord. If your lordship see the sweep of the directions in Asian resurfacing, my lord, in the compilation page 29. If I can read that, not 5 lines from that judgment. If your lordship go to the convenience compilation of Mr. Dwivedi, my lord, the judgment started page 3 of the compilation at page 29, just before paragraph 38. Lordship would see the sweep.
What page will that
In
be?
page 29, my lord, just starting in all pending matters before the high courts, my lords have got it.
Yes.
In all pending matters before the high courts or other courts, which will include special courts, etc., relating to the PC Act and all other civil or criminal cases, where stay of proceedings in a pending trial is operating, stay will automatically lapse after 6 months from today. The judgment is not delivered, unless extended by speaking order
on the above parameters. Now, next line is also important. Same course may also be adopted by civil and criminal appellate revisional courts under the jurisdiction of the high courts. The trial courts may, on expiry of the period, resume the proceedings without waiting for further intimations. But sweep of the directions, it never been,
My Lord, lots would see, I'm so sorry. Lordship would see the consequence on a diligent litigant, my Lord. He convinces the court, passes an interim order, thereafter listed after 1 month. It does not reach, or the respondent seeks an adjournment. The court is not able to take it up despite being on the board. I wait for the entire day, my Lord. It doesn't reach. It happens, my Lord, in so many courts, my Lord. All of your Lordship knows someone, my Lord.
So, my Lord, as learned attorney has rightly said, but it is upon the institution, my Lord, whether it is able to decide it or within that 6 months time limit or not.
Anything else?
And my Lord, only one thing, my Lord, wherever the courts find, my Lord, that preemptory order is upon again the judicial discretion, my Lord. Sometimes your lordships and courts pass, it will operate for a period of 6 months or, my Lord, 4 weeks. So, my Lord, that qualification is given, my Lord, in the order itself, that this stay will operate for a period of 4 weeks and it expires automatically. That judicial discretion is available to the court, my Lord, which this court, my Lord, in SS surfacing south, my Lord, that it automatically vacates. Wherever the court wants it, it should automatically vacate. That is stipulated in the order itself. Sometimes by your lordships, my Lord, while exercising that discretion of the court, my Lord. So it cannot, my Lord, automatically vacate by virtue of this.
We do it so often over here, instead of saying notice returnable in 6 weeks, because if you say notice returnable after 6 weeks, sometimes we found that matters were coming back after 5 years.
Yes, my Lord, it has happened.
So we list it on a particular day and say that the interim order will be up to a particular day. So we have control over it.
No, and
we know that the petitioner will also come back to us for extension of the order.
And thereafter also sometimes it does not reach, my Lord. On that particular day, it is on board. It does not reach. And the respondent seeks an adjournment, my Lord. Circulates a letter and gets an adjournment after. Lord, but there are various circumstances, my Lord.
All right. Thank you, Mr.
I'm extremely grateful to your Lordship.
Right.
We've got your note here.
501.1, my Lord. Lord, I respectfully adopt, my Lord, all that my learned seniors before me have said, my Lord. The 1 or 2 things, my Lord, that I may want to add. The genesis of my matter, my Lord, is a classic example of the problems with, my Lord, Asian resurfacing.
Right.
This is a criminal trial. These are advocates, my Lord, who appear for an accused. They have been roped in, my Lord, as conspirators with the accused, my Lord.
Yes.
I secured a stay, my Lord, in the High Court in 2014. Matter doesn't come up, my Lord. The stay now stands vacated by the orders, my Lord, that I have impugned before your Lordships.
Only on the ground, not on the ground that I'm seeking an adjournment, not on the ground of anything else, not on the ground, my lord, that the state deserves to be vacated for A, B, or C
Only on the
reasons.
ground of Asian resurfacing.
Only on the ground of Asian resurfacing.
Yes.
So, my lord, most of it has already been said, my lord. I'll just take a couple of minutes, my lord. May I only point out, ultimately, my lord, judicial discretion, my lord, is the essence of the adjudicatory process. What Asian resurfacing has done, in effect, is completely, my lord, taken away that discretion that the Honorable High Court, my lord, has exercised or is to exercise in respect of giving interim orders. It's
Yes.
not that an interim order is not given by without application of mind, my lord. Your lordships have already observed, and others before me have already argued, my lord, that the aspect of application of mind is taken away. What it also does, my lord, is dilutes the power of the High Court under section 482 as well as, my lord, 226.
Yes.
Finally, my lord, I'll just put it all in the note, my lord. I don't want to waste your lordship's time. The basis for Asian resurfacing, my lord, if your lordship see paragraph 36 and 37, the basis for Asian resurfacing is a judgment called Imtiaz, my lord.
Yes.
Where your lordships, my lord, have discussed the delays in trials, etc. There is really no reasoning, my lord, why Asian resurfacing paragraph 36 and 37. But the intent, my lord, is very good. The intent, of course, my lord, is to avoid delays in trials and promote speedy trials. There can be no doubt about it, my lord. But there is no specific, as Mr. Dwivedi has already argued, never arose, my lord. But I'd like to end, my lord, with what Justice Holmes said, my lord. Life of the law is, my lord, experience, not logic. Asian resurfacing is probably logic, my lord. The lordships, my lord, 5 years of experience, my lord. Grateful.
Thank you. Thank you, Mr. Pai.
Lord, Mr. Mehrotra is appearing online, my lord, if I may be permitted to address.
Anything else, Mr. Mehrotra, apart from what has been said? Please unmute yourself. You're not audible. Mr. Mehrotra, you're not audible. You'll have to. You're still muted, actually, at your end. Yes, now you're unmuted. All right, you just set your house in order. We'll hear Mr. Naski in the meantime.
But I
Mr.
appear
Naski.
in Mr. Pai's matter for the state of Andhra Pradesh, and I completely support my lord Mr. Pai in that. Not just one addition, my lord. My lord, what your lordships have done, my lord, in the judgment is that you have also imposed fetters, my lord, on the very exercise of jurisdiction. And I would only draw your lordship's attention, my lord, to a constitution bench judgment of 1964. My lord, I've passed on the judgment. It is AIR 1964 SC 1573. Your Lordship Gajendra Gadkar speaking.
What is the name of the judgment?
My lord, the name of the judgment is B. Rajgopala Naidu versus State Transport Appellate Tribunal. My lord, here,
What is the para? What para would you be referring to?
my lord, para 19 would be relevant, my lord. I'm only drawing a parallel where, my lord,
We now request all members of the bar to start citing SCR. Because SCR is now up to date up to the last few
there
days.
is an SCR citation also, may I?
And with neutral citations
Yes,
as well.
We would certainly do that.
And now that the Allahabad High Court Bar Association is before us, ESCR has now 30,000 judgments in Hindi. All judgments of the Supreme Court since independence are being translated into Hindi. It's in a searchable format. So exactly the facility which you have available on the English SCR, you have in the Hindi SCR. So please spread the word and
Lord, what was sought, my lord, to be done in this judgment is that by what?
and this is being now extended to other Indian languages, brother. Oak is very actively monitoring that.
My lord. Lord, what was sought to be done, my lord, in this judgment is by way of a statute, my lord. A fetter was sought to be imposed on how the quasi-judicial authority would exercise jurisdiction, my lord. But that your lordship said is not permissible. Would your lordship have para 19 minutes? I have, sorry.
How does it begin?
My lord, may I just pass on the hard copy?
No, we have it here right in
My lord,
front
it
of us.
says-
You have it on your screen as well. All the lawyers will have it on your
My lord,
screen. Here
in
it is.
reaching the conclusion.
Yes, we got it.
That's the one. My lord. In reaching the conclusion, we have been influenced by certain other considerations which are both relevant and material. Now the relevant part. In interpreting section 43A, we think it would be legitimate to assume that the legislature intended to respect the basic and elementary postulate of rule of law, that is, that in exercising their authority and in discharging quasi-judicial function, tribunals constituted under the Act must be left absolutely free to deal with the matter according to their best judgment. It is of the essence of fair and objective administration of law that decision of the judge or the tribunal must be absolutely unfettered by the extraneous guidance by the executive or administrative wing of the state. My lord, if the exercise of the discretion conferred on the quasi-judicial tribunal is controlled by such direction that forges fetters on the exercise of quasi-judicial authority, and the presence of such fetters would make the exercise of such authority completely inconsistent with the well-accepted notion of judicial process. My lord, so
Yes, all right.
my lord,
Thank you.
just drawing a parallel.
Anything else?
Lord, Mr. Mehrotra, I don't know if he's able to come.
Mr. Mehrotra? Is someone appearing in person?
No, Your Lordship will then allow me to place my.
Yes, Mr. Mehrotra.
There seems to be some.
The problems is persist, Mr. Mehrotra. If you filed your written submissions, we'll read them.
Yes, fine.
No, that-
You have filed your written submissions, we'll read those.
Yes, fine.
All right. Anybody else? Are we all done?
Lord, I just wanted to add, my Lord, one judgment, my Lord, Mittu versus Punjab, Your Lordship will recall, my Lord, taking away of judicial discretion.
That's right. On the death penalty.
Yes, yes. Grateful.
Very well done.